This is gone High Court. I told you. I called him, he's not in town. He's not in town. ಶಶಿ ಇದರಿಂದ ಇಲ್ಲ.
Comments?
2000. It will come as regular course. All women are going. In who's harassing? Huh? Who's harassing you? Dismiss are in and harass. Who are you? You are applicant. Dismiss. You filed application. Who was filed? You appellant antaralri. Why do you worry when the appeal is dismissed? What are you going? So how are you affected? What you are now trying to move? Which application?
Amendments page wise, page 7, syllabus 26 and 27. Seven.
Serial number? Your appellant. Counsel for appellant seeks time on the ground that they are exploring possibility of settlement. Release this matter after 2 weeks.
Page 8, syllabus 28 to 31. Page 9, syllabus 32 to 35. Page 10, syllabus 36 to 38. Page 11, syllabus 39 to 44.
Lord, serial number 42, my lords. I am for the respondent. May request for just 2 days time, my lord. I've been unwell for the last 2 days. I've informed the appellant counsel as well. Thursday, I'd be grateful. Thursday or Friday.
Request of counsel for appellant.
Respondent, my lord. I am for the respondent. I've informed the appellant.
Release this matter on 14.
I am for the respondent, my lord.
All right. 14.
Obliged, my lords.
Page 12, syllabus 45 to 49. Page 13, syllabus 50 to 55. Page 14, syllabus 56. Serial number 1. Someone who may read dilemma.
Counsel for the appellant is present. And a memo dated 23rd August 23. Annexing the newspaper publication of notice having been taken out in respect of respondent number 1C in Samyukta Karnataka Kannada Daily Newspaper of Bangalore edition, dated 27/7/2023. Respondent number 1C is called out.
Firstly, Srimati Sarojama.
In open court, there is no representation by herself or through her lawyer or through her lawyer. Notice is held to be sufficient. History to show her name in the cost list. You have paid cost, is it? Along with receipt for having paid cost. That's for acceptance. Cost rupees 500. Paid by the appellant is accepted. The Advocates Association Library Fund. Then appellant is there. In non-filing of wakalat.
My lord, serial number 2, my lord, I appear for the appellant, my lord. I request for 1 day accommodation. Today I have received the wakalat, my lord. File it, my lord. 1 day accommodation.
On number 2, Your Honor.
For whom you have to file wakalat?
For the appellant, my lord.
All.
Yes, my lord. One Subrayappa.
Counsel for appellant seeks 2 days time to file wakalat. Release this matter on 20th.
I think who responded in this case.
Which respondent?
Number 2, Your Honor.
Counsel for R2 is present.
Number 3, B.S. Prasad.
And who was died? Yavaga. When? Okay. How many appellants are there? Huh? Appellant. When did he die? No, why your party has not responded? What's your name? Senate Counsel Harish B.S. on behalf of Prasad. B.S. Prasad is present. I'd order dated 2/3/2023. Counsel for the appellant had reported the death of sole appellant. Matter was adjourned to take steps in 2 weeks' time was granted. Thereafter, on 20th June 2023, again the appellant counsel took time. Again on 11/8/2023, counsel for the appellant took time to take steps to bring the LRs of sole appellant on record. Even today, counsel for the appellant seeks time. Until date, no steps are taken to bring the appellant LRs of the appellant on record. In view of non-taking of steps, appeal is dismissed as abated. If you are not serious with the case, nobody can help you. Connected with you. Even in that also same appellant? Different appellant? Right. Not even same or different? Registry to D-Link RSA 1233 of 2009 from this case. Non-compliant officer judgment, amended appeal. PF code for what? The notice to R2, A and B. Which legal error, sir? R2, A and B ge notice ಹೋಗ್ಬೇಕಾಗಿರೋದು. ನೀವು ಯಾರಿಗೆ? For whom? File ilva ನಿಮ್ಮ ಹತ್ರ? You know why you are bent upon wasting the time of court. Open and see who's A and B. Is there any other errors? What is your name? You have filed I1. For what? For what? Learned Counsel, there is no representation on behalf of appellant. Learned Counsel, Mr. Jagdishachari does not know for which respondent he appears. Release this matter next week. Counsels to ascertain and make proper submission. Who has died? Who has died? A1 year. Already. Leave it, man. Call the next case.
I appear for the appellant in this case, my lord. Respondent file and memo, my lord, reporting the death of respondent.
Cool. Operena.
Operation. I will pray a week's time to bring the LRs.
Learned Counsel for the respondent has filed a memo reporting the death of sole respondent who died on 11/1/2021, leaving behind the LRs as mentioned in the memo, along with the copy of the death certificate. Counsel for the appellant seeks time to take necessary steps. Delist. A week's time is granted.
Much obliged.
Number 6, Sri Narayan MS.
Sri Vinod Reddy.
Justice,
Just to carry out amendment. Whether his appeal is admitted. A week's time granted to do the needful. There's no, before that, no representation for appellant. Counsel for respondent number 3A to D is present.
okay.
R3 has died. When? ಒಂದು ವರ್ಷ ಮೇಲೆ ಆಯ್ತಲ್ಲ. No, when it was reported, when you came to know. Order itself is last 2 years back. ಸತ್ತಿದ್ದಾರೆ. While order dated 8/9/2020, counsel for the appellant is present. While order dated 8/9/21. It is noted in the order that counsel for respondent number 2 filed a memo dated 6th February 2020 reporting the death of respondent number 3 along with photocopy of the death certificate showing respondent number 3 having died on 14/11/2011. and appellant sought time to take steps to bring LRs of R3 on record. Till date, no application is filed, no steps are taken to bring LRs of R3 on record. Hence, appeal against R3 abates.
Great. Next one.
R4 or 9. So,
For the same. Respect of R4, 5, 6, 8, and 9 is served after.
sufficient. We noted postal shara. The court notice report is received from the district and session judge Mysore in respect of respondent R4 to R9 having been served on the family member, that is R7, who's already served and represented R7. Hence, the service of notice is held sufficient to R4 to R9. What is there order? Counsel for the appellant has filed a EA number 1 of 23 for taking out newspaper publication by way of substitute service to respondent number R1B and D in the Kannada Prabha Mysuru edition. R1B and D. The said application is allowed. The appellant is permitted to take out notice by way of substitute service in Kannada daily newspaper, Kannada Prabha Mysuru edition, shall be taken on or before
27th September 2023 by showing next date of hearing 11th October 2023.
For getting the last.
2 and 3. They are already on record. But counsel for appellant has filed memo dated 11/9/17 to treat respondents number 2 and 3 as LRs of deceased R1. Same is accepted. LRs of deceased, the R2 and 3 shall be treated as LRs of deceased R1.
9 PL.
2 weeks time granted to file paper book. 2 weeks time granted to file paper book. Counsel for appellant is present in both cases.
Ma'am, serial number 19.
You have taken out the notice? No, you have filed IE. You want to file a week's time granted request of counsel for appellant. You have paid. When have you taken? ಇನ್ನ 4 ವರ್ಷದ ಹಿಂದೆ ಕತೆ ಹೇಳ್ತಿರಲ್ರಿ. ಆಗಲ್ಲ ನಿಮ್ಗೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಅವಾಗಿಂದ ಪಾಠದಲ್ಲಿ. Wait a week's time is granted if needful then registry to issue notice to R2 and R3. Why? Why it should be overruled? ರೂಲ್ ಇದ್ರೆ ಅವ್ರು ಕೇಳ್ತಾರೆ ಮತ್ತೆ ಕ್ಯಾಶುವಲ್ ಅಂದ್ರೆ ಹೆಂಗೆ ಅದು ಇವು ಯಾವ್ದು ಹಳೆ ರೂಲ್ಸ್ ಹೇಳಿದ್ರೆ ನಾವು ದಿ ರೂಲ್ಸ್ ಕಮಿಟಿ has made a rule, full court has approved it, and maybe after discussion with the members of the bar they say you have to give full cost title. ಅದು ಕೊಡಿ, I will pass the order. All right. So, this is R2B. Alive. What is the name of R2B? ಏನ್ ಹೆಸರೇನು? ಯಾರ ಹೆಸರೇನು? ಶರ ಬಂದಿದೆ. All right, then you take notice. But R2B ಸರ್ವ್ ಆಗಿಲ್ಲೇನು? But since the notice has come back as dead, you take out once again. Local Learned Counsel for the appellant is present, seeks a week's time to comply with the objection raised by the registry. If the 1 minute, sir, please listen to the order. A week's time to comply with the objection raised by registry. If same is complied, registry to issue notice on IA 1 of 2022. Learned Counsel submits that he has done the needful with regard to the payment of process fee and correct address. Same is in order. Issue notice to R2 within bracket C and F, R4 within bracket D, and R5 to 8. Counsel for appellant submits that this is the respondent number 2B, namely Srimati Kantamma. Kantamma is alive, but the postal shara depicts that party is dead. However, in view of the submission made by counsel for appellant, he shall take steps once again to respondent R2B. ಮಾಡಿದ್ದು notice on IE number 1 of 22 notice. If you comply, notice will go. ಒಂದು ಟೈಪ್ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ, 1 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇಫ್ ಕಂಪ್ಲೈಡ್, registry to issue notice. The objection raised on your IA. Your filed application, and along with that delay application is filed. Still, week's time granted at request of counsel for appellant.
For the appellant, my lord,
Yes.
not short accommodation to comply.
When did R2 die?
In 2017, Anta, this was submitted by R1 in the last date of hearing, my lord. We have to get instructions from party with respect to address LRs and.
Request of counsel for appellant, a week's time is granted. 1 week granted. What is the objection?
Highest to be filed in respect of R7 and 8, date of death in respect of R8.
Last time ಬಂದಿತ್ತ ಒಂದ್ಸರಿ. Last time ಬಂದಿತ್ತ ಇದು? ಏನ್? You have to file separate IA. Week's time granted at request of appellant. No representation on either side released next week. Who's appellants? He died on 18. How will you know at the time of filing of the appeal? Appeal is in 2013. Who has filed the memo? Have you said anything about the LRs? Have you said so in the memo? Counsel for the appellant has filed a memo dated 2/4/2019 stating that the fourth respondent died on 24/10/2018. The appellant herein is the only LR of fourth respondent, and that the appellant may be treated as the LR of fourth respondent. Memo on submission of counsel for the appellant is accepted. Counsel for the appellant to carry out the necessary amendment and file the amended cost title with serving copy on the other side. It's 4 times. Unserved R2D, Venkat Subbarao. Week's time granted. Take necessary steps. No representation on behalf of appellant on either side.
Lordship, in serial number 19, I appear on behalf of the appellants, Your Lordship. Paper
Yes.
book may kindly be accepted, Your Lordship. That's my first submission. Second, Lordship, the name of Prasanna Kumar be deleted, Your Lordship. He's become independent. And name of Jadhav Law Associates be shown, Your Lordship.
Which is that order of 29/10/21. The counsel for the appellant is present. Go to the registry and take it. The counsel for the appellant is present. He has filed the paper book on 21/1/2022. Same is accepted. What else is the requirement from the counsel for respondent to present? Whose name to be put?
Lordship, Jadhav Law Associates, Your Lordship. Jadhav Law Associates.
Registry, delete the name of learned counsel Prasanna Kumar P and instead include the name of Jadhav Law
Associates.
Associates as counsel for appellant.
Yes, Your Lordship.
Have you given copy for the respondent?
Lordship, to the best of my knowledge, it has been given, Your Lordship. If they want, we'll serve it again.
How many appellants are there? You have filed for all. Who has filed memo? Who has filed memo? Who is the advocate who has filed memo? Mallappa. What about Ramesh? Who's Ramesh? He has filed NOC now. Who are you appearing, madam? On whose behalf? On whose behalf you are appearing? What's the name of the council? Ah, ah. Where is it showing? It's only your statement. How many appellants are there? You have filed memo only for one and 4. Yes. Huh? 19. Ramesh Kumar ಯಾರಿದ್ದಾರೆ? Ramesh Kumar. So whether he has filed NOC from these people, we doesn't know.
Appellant 1. Yes, Ramesh.
Current Council Sri PM Siddhamallappa is appearing for the appellants, has filed a memo of retirement on behalf of appellant number 1 and 4. Council Sri Ramesh Kumar has filed wakalat on behalf of appellant number 1. In view of the said wakalat having been filed for R1, A1, Learned Counsel Sri Siddhamallappa PM is permitted to retire from the case on behalf of A1. So also in view of the memo of retirement filed for RA4 and the retirement memo having been signed on by the appellant number 4, he is also permitted to retire on behalf of A4, appellant number 4. Registry to issue court notice to appellant number 4. Full stop. Learned Counsel R19 has filed a memo of retirement. Thank you. You are for R19? Yeah. Without the notice. Notice ಕೊಟ್ಟಿದ್ದೀರಾ ಪಾರ್ಟಿಗೆ? ಕೊಟ್ಟಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ? You understood what I asked you? ಕೊಟ್ಟಿಲ್ಲ. ನೋಟಿಸ್ ಕೊಡದೆ ಹೆಂಗ್ರಿ ರಿಟೈರ್ಮೆಂಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡೋದು? Or you have to take the signature of your party. Memo for retirement filed by R19 cannot be accepted, same is rejected. Hmm? You are appearing for 2A to 2D. With no representation on behalf of appellant in the matter is called out at 11:18 AM. Counsel for respondent R2A to D is present. Call this matter later. You are the RSA, you have filed RSA CROB. Cross objection is filed by you. All right, I'll grant you, I'll grant. Yes, sir. ಯಾರು? We'll have to see from the order sheet whether it is gone. What is this matter, by the way? Partition suit in.
Take up all kinds of defense and all the courts below, all that in property was the absolute property. Then, one paragraph, the entire judgment is negated. This paragraph is there. Thinking on the state of the innocence. That is done. Our oversight. If you want to control, there is no other part of the. You want to debate, separate court debate. Both of them know at first. You are also. Both code. Separate code. Separate code. Who also can load the code.
Yes.
Yeah, there is no question of law involving. Accept the same. Question of law the same. In my case, as far as the law is concerned, there is question of law involved. I think that if I am given an opportunity by law, I have a very strong case.
What is the objection, everyone?
Doing this, that I have to undergo means and benefits. One active or
Appeal is by the defendant, is it? What about in the CROB? No, what is your name? What is your name? Who was filed? But it is showing us Vasanta Lakshmi, yes, Patil. The RSA crop 7 of 2015, 14% is shown as Vasanta Lakshmi. Then what is your name is Simha? Where is that crop? So in the RSU, you have filed crop. That's why it is shown, but your name should, cross objector should be shown in the name of cross objector as party in person is not shown. Vasanta Lakshmi is shown. Vasanta Lakshmi is shown as cross objector, party in person. But you are appearing for Vasanta Lakshmi, who's the plaintiff. That is wrong then.
ರೈಸ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನೇ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ
ಹೌದು.
How R1 is present in the application. Correct.
See, Mr. Narendra Simha, you have described in the appeal memo cross objection, your cost title itself is wrong. That is one of the objection. All right. PIP hogidara. PIP. You have gone before the party in person committee. You went here. I'll come in. I will hear you. I will hear you on the main matter. Yes, first you, Mr. Please, you first rectify your objections which is raised. There are several objections. Rectify the first, the cost title itself, which is wrong. That is one of the objection and several others. I'll grant you 1 week's time.
Mediation, the promulgation, please.
No, it would not have happened in 2015. Go get it out. You go before the party in person committee. Now you have not gone there. So go before the committee, you obtain a certificate that you are capable of arguing your case yourself. The party in person committee will interview you, find out whether you are capable of arguing. There are certain terms and conditions which you have to adhere to while you appear before the High Court, maintain the decorum and so many other things are there. First go there. In the meanwhile, you rectify the objection, go there and obtain the certificate. Learned Counsel Shri Sitaram Rao, our appellant is present before the court. Matter is not admitted yet. It's not admitted yet. Admit ಆಗಿಲ್ವಾ ಇನ್ನು? Oh, you are not right. On 30th March 2021, matter is admitted. Substantial question of law is framed. Now, into the suit, your suit, you filed the suit. Plaintiff. There is a question of whether the suit for partition in respect of joint family property was maintainable under Hindu Succession Act. It goes against you. That question goes against you. Question of law is framed. I think you don't have it with you. First question is whether the courts below are right in partitioning the suit properties in the light of judgment of apex court in the case of Prakash, others, and Kulavati and others. Second, whether the suit for partition in respect of joint family was maintainable under the Hindu Succession Act of 56 in view of judgment in G. Sekar and Gita. Paper books to be filed in 8 weeks. This question of law goes against you.
The question that we not have considered is the practice in the absolute property.
This is the question of law. ಏನ್ ಬರ್ದ್ರಿ? The party in person, Narendra Simha, who has filed RSA CROB 7 of 2015 is present in person. Full stop. There are several objections raised in the RSA CROB. The objections are not rectified. The party in person, Sri Narendra Simha, is directed to appear before the party in person committee to obtain the certificates as per the rules for appearing as party in person. He shall appear before the party in person committee. Date for appearance. On 26th. Why you want such a long time to go before the committee? You're from Bangalore. Mysore, already 26th. No, they will guide you on 26th September to appear before the committee. To appear before the committee and obtain necessary permissions for prosecuting this matter as party in person. Of course, I'm to comply with the objection. Have a look, Mr. Sitaram Rao. Question of law, Nodi. Dispensation will not arise. You have a look at that. Because I think that may still have to be modified if you are not happy with that. See, once this is admitted, if you are not going to rely on any paper book, anything, then it has to be dispensed. Otherwise, as per the rules, you are supposed to file paper book. All right, I will record so.
W1 and DW1.
Unit Counsel for the appellant files a memo seeking dispensation of production of a paper book. At his risk, paper books are dispensed. Filing of paper book is dispensed. In days, delay other filing appeal. Along with statement of objection, new file material. There are counsel for the appellant and the counsel for the respondent. Respondents are present. This IE number 1 of 2012 is filed, seeking to condone the delay of 14 days in filing the appeal. Objections have been filed to the said application. I have perused the affidavit annexed to the application and the objection statement. Being satisfied with the reasons assigned and cause shown in the affidavit, the delay of 14 days is condoned. IA number 1 of 12 is allowed. He has to come for hearing, admission. Admission agidya? Illa. He has to come for list this matter for admission on 29th. 29th is a working day. Alla? Yaru? Who has died? Has died. ಅವ್ರು ಹಾಕಿದಾರಲ್ಲ ಲಕ್ಷ್ಮಮ್ಮ, ರಾಘವೇಂದ್ರ, ರಾಜೇಶ್, ಪಲ್ಲವಿ. ಏನ್ ರೀಕಾಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ? Great. So he has filed application for recalling and the setting aside abatement. Why can't you mention the correct name as what is given by him? Yeah, Nim party is good. Sathirad yaru? Idu Nim party gottidya correct aga? How can it differ from what he has stated? When what is a suit for? Suit for bare injunction, you know? Concurrent finding. KT Mahadeva ಅವರು ಅವ್ರ ಮಕ್ಕಳು KT Mahadeva ಮಕ್ಕಳು ನೀವು ಎಲ್ಲಾರು ಸಾಕಿರೋದು. Our details of Mahadev's wife and children he has already given. You want to give your own names? And the address also is different. Elvatta village, Columbia Hospital, GRS Ring Road, door number 182. Anyway, now you have filed Vakkalatalla. Let us see your Vakkalat. So what do you want to do with your application? ಕಲೆಕ್ಟರ್ ಅವ್ರ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಆಲ್ರೆಡಿ ಇದೆ ಅದು 3rd March 2021 ಅಲ್ಲೇ ಅವರು he's given death certificate, name of the LRs, address of LRs along with Aadhaar card. He has made your life easy, but you want to further complicate it. Instead of going straight, you want to go entire world and come back to Mysore. ಎಲ್ಲ ಹೇಳಿದ್ರು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ I cannot. Also for the appellant is present, learned counsel for respondent number 1 A to D is present, who has filed wakalat on behalf of LRs of R1 within bracket A to D. The application filed by the appellant to bring the LRs of R1 A to D differs from the memo filed by respondent R1 describing the LRs in the form of R1 A to D in by name and address. Counsel for the appellant to rectify the same. Released next week. You are not so loud that I can hear you. You can use the mic or you be loud enough. Makkali. I have counsel for appellant and respondent number 2 are present. IA number 1 of 22 is filed by our respondent number 2 for early hearing. Application is allowed. This matter for hearing on Yavaga 4th October. So you are appearing for appellant. You are reporting death of R1. Counsel for appellant is present. He reports the death of respondent number 1. Date kotilva. A week's time is granted to take steps to bring LRs of R1 on record. 2 weeks, 2 weeks. Vinay. Agidiyalla? Why it is posted to some more arguments? Howda? Can you just refresh my memory? Appeal is filed by whom? Plaintiff's appeal. Partition, injunction. Can you brief me? What is the suit filed by plaintiff for what? Hmm. 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 Yaru. Okay. So respondents were not allotted the site. They approached the High Court in writ petition. The writ court directed for allotment. Law. Hmm.
Seven persons. One so we have to go on seven of the we have allotted the state they have started to find a petition.
The plaintiff filed earlier one more suit in 274.
Yes, I do more, but it gets not disclosed. Number is like 85.
So what is the main contention of the appellant plaintiff? That he cannot be discussed without due process of law.
The progress documents, created documents. Left of the created documents, it is not asked for the process of law, it should be. Then we start about myself, that person decide out. There are multiple of the updates for the policies that issued by 495. Clearly go to show the detail of the soul of Lord, prayer for that the soul is not that the difference of the is not influencing. He becomes a rank of trespasser and protection is not available to me. Against the two over, the increase of relief of agency is not available to for the question of the proportion of.
Issue number 1 to 3 is held negative. So that is, I think, set aside. Whether plaintiff proves that he is in lawful possession. The suit which can cite as on date of the suit or the plaintiff proves the alleged interference. So all the issues are against the plaintiff. Workable. Workable, I was admitted. Leave any blank. I've learned counsel Shri Vinay on behalf of Manmohan PM and learned counsel B.S. Nagaraj for respondent number 2 to 4. 2 to 4, huh? 2 to 4. The appeal is referred by the plaintiff challenging the judgment and decree dated 15/6/2012. Passed in RA number 381 of 2009. Kutkoli, sir. Old number 373 of 2006. By the 6th Additional District Judge at Mysore, wherein he confirmed the judgment and decree dated 19/10/2006, passed by the 3rd Additional Civil Judge Junior Division, Mysore, in OS number 315 of 1995. Huh? District Judge ಯಾವುದು? Second Additional 1. Correct, is the Civil Judge OS number is 31. But here he has mentioned third, what to do, the appeal. By passed by Second Additional 1 Civil Judge. Second Additional number 1 Civil Judge Junior Division. Parties to the proceeding shall be referred to as per their status and ranking before the trial court for the sake of brevity. The plaintiff filed a suit in OS number 315 of 1995 against the defendant for the relief of permanent injunction. It is the full stop. It is a case of plaintiff. The suit schedule site bearing number 9, measuring 30/40, situated at, within inverted commas, K block Kumbara Koppallu, Mysore, was granted to the plaintiff by the Mysore City Corporation through allotment letter dated 22/8/1978. And thereafter, he remitted an amount of rupees 169.30 by receipt dated 6/9/78. Full stop, pursuant to which it is claimed that plaintiff was put in possession as per possession certificate dated 22/3/82. Full stop. It is also pleaded that Mysore City Corporation executed a title deed in favor of the plaintiff and conferred the suit shuttle property title to the plaintiff. This being the state of affairs, when the plaintiff started putting up construction in the suit shuttle property, the defendant started illegally interfering with the peaceful possession and enjoyment of the same. Full stop. Therefore, the plaintiff was constrained to file a suit for injunction against the defendant. Accordingly, the suit came to be filed. Para. Defendants appeared and filed their statement of written statement denying the averments made in the plaint by the plaintiff. And took up a plea that the Mysore City Corporation published a notification dated 14/3/78 calling upon applications for allotment of sites to those siteless and land losers. And the defendant being a land loser and a siteless person applied for grant of site within the stipulated time prescribed therein by the Mysore City Corporation. Full stop. Mysore City Corporation allotted in all 165 sites in favor of different persons coming within those categories of land losers and siteless persons. But the defendant herein was not allotted the site. Hence, being aggrieved by non-allotment, he filed a writ petition before this court, questioning the validity of the allotment made by Mysore City Corporation. The writ petition came to be filed in WP number 18557 of 1985 and 18558 of 1985. This court allowed the said writ petitions preferred by the petitioners therein and directed the Mysore City Corporation MCC within bracket to allot sites to only those eligible and suitable land users and siteless persons. Full stop. In following the orders of this court in the aforementioned writ petitions, the sites allotted by MCC to 165 persons were cancelled. Okay. The petitions referred by the petitioners therein was directed to be considered in accordance with the law. And accordingly, the ಯಾರು ಮೆಮೊ ಹಾಕಿದ್ರು corporation filed a memo dated filed a memo dated 6/8/1986 by undertaking to consider all the applications of the petitioners for allotment of sites within a period of 3 months, if they are so eligible. On the basis of the said memo filed by MCC, the writ petitions came to be disposed of. Full stop. It is further pleaded by the defendant that pursuant to the same, the Standing Committee for Finance and Taxation of the MCC took up the matter for consideration and decided to allot the site in favor of defendant and other writ petitioners. And in accordance to the same, a resolution was passed by allotting the site measuring 30 into 40 in favor of defendants. And he was directed to pay the allotment price. It is further pleaded that the defendant paid the said allotted price and was put in possession of the site along with other writ petitioners. And thereby the defendant came into possession of the suit schedule property. Full stop. It is also pleaded that the corporation MCC cancelled the other illegal allotments made in favor of ineligible persons, including the plaintiff herein. Full stop. On the basis of these pleadings, defendant sought for dismissal of the suit. On the basis of pleadings, the trial court framed the following issues for consideration. Page 46, issue 1 to 4. Para. In order to substantiate the issue and prove the case, plaintiff got examined himself as PW1, got marked exhibits P1 to P8, whereas the second defendant examined himself as DW1 and examined two other witnesses, DW2 and DW3, and got marked exhibits D1 to D24. Stop. Para. On the basis of material evidence, both oral and documentary, and on hearing the learned counsel representing the plaintiff and the defendant, the learned trial judge, after considering all aspects, keeping in view the issues framed, decided all the issues against the plaintiff and dismissed the suit of the plaintiff. Para. Being aggrieved by the dismissal of suit, plaintiff preferred an appeal under section 96, read with order 41, rule 1 of CPC, challenging the correctness of the judgment rendered by the trial court. Full stop. Para. Upon consideration of the first appeal, by way of a re-examination and re-appreciation of the entire material evidence placed on record, both oral and documentary, and on hearing the learned counsel for both the parties, the first appellate court framed the following points for consideration. Page 21, points 1 to 5. Full stop. Upon reappreciation of the entire material placed on record, both oral and documentary, and on considering the arguments put forth by the learned counsel for plaintiff and defendant, the first appellate court, partly agreeing with the judgment and decree passed by the trial court, dismissed the appeal filed by the plaintiff and allowed the cross objection filed by the defendant to the limited extent of striking down paragraph number 16 and 17 of the judgment of the trial court. Therefore, the first appellate court confirmed the judgment and decree of dismissal of the suit passed by the trial court. Full stop. I've heard the learned counsel Sri Vinay on behalf of Manmohan PN for appellant plaintiff and learned counsel BS Nagaraj for respondent defendant. It is the vehement contention of learned counsel for the plaintiff that both the courts committed a serious error in not considering the material evidence placed on record, both oral and documentary, and so also ignored the well-settled legal principle and thereby have passed an erroneous judgment by dismissing the suit of the plaintiff. It is a further contention of learned counsel for the plaintiff that when there are serious charges of forgery and concoction of document alleged against the plaintiff, the trial court and the first appellate court could not have mechanically arrived at a conclusion by dismissing the suit of the plaintiff without dealing with the documents so alleged to be fraudulent and concocted or forged by the plaintiff, which has been totally ignored by the trial court as well as the first appellate court. In fact, he further contends that these were not the pleadings before the trial court, and it is subsequently taken up in the first appellate court. Therefore, when matters are not pleaded before the court, the same cannot be adverted to when no such pleadings are made by the parties before the trial court. It is further contention of learned counsel for the plaintiff that Exhibit P1 is a title deed executed by the Commissioner MCC on 16/9/1994. And Exhibit P2, P3, P4, and P6 are possession certificate, tax paid receipt, Khata extract, and the amount paid towards grant of license, and several other documents having been placed by the plaintiff, which clearly depict and go to show that the plaintiff has been in peaceful possession, enjoyment of the suit schedule property as the owner was the owner. He further contends that the defendants have not questioned the title executed in favor of the plaintiff, and there being no challenge to the validity of the title deeds in favor of the plaintiff. The trial court and the first appellate court erred in coming to a conclusion that this plaintiff has not proved his case with regard to ownership, possession of the suit schedule property. It is further contended by the learned counsel for plaintiff that since there is no challenge made to the title and the execution of the title deeds by the Commissioner MCC in favor of the plaintiff, and no declaratory relief is sought by the defendant, the question of dismissing the suit of the plaintiff would not arise, as the documents produced by the plaintiff in exhibits P1 to P6 and other documents clearly depict the transfer of title and ownership and possession in favor of the plaintiff by the MCC. This aspect of the matter has been conveniently ignored by the trial court as well as the first appellate court. Full stop para. Learned Counsel further contends that the trial court has lost sight of the suit filed by the plaintiff, which is only for permanent injunction, and has gone on to advert the issues with regard to the plaintiff being minor at the time of filing the application for allotment of site. And on such presumption, the trial court has dismissed the suit by traveling beyond the pleadings before the trial court. It is further contended by Learned Counsel that it is also the finding of the trial court that the plaintiff is in possession of the suitable property, and accordingly, the trial court came to a conclusion that the plaintiff is in possession of the property as mentioned in para number 16 and 17. Learned Counsel further contends that in view of the fact that exhibits D1, P1 to P8 produced by the plaintiff clearly depict and show the execution of the title deed by way of Hakkupatra by the Commissioner Mysore City Corporation MCC, and the issuance of possession certificate, payment of tax, issuance of khata letter, the license letter and acknowledgement issued by the MCC, it is very clearly apparent that the plaintiff is in peaceful possession and enjoyment of the suitable property, which has not been disturbed. This aspect of the matter having been ignored by the trial court and the first appellate court, the judgment rendered by both the courts are erroneous. The same requires to be set aside and reversed. He further contends that the first appellate court, upon reappreciation and reconsideration in the first appeal under section 96 and order 47 rule 1 of the Code of Civil Procedure, has failed to consider all these aspects under 41 rule 1, failed to consider all these aspects despite raising the relevant points for consideration. On the contrary, the first appellate court has modified the judgment and decree of the trial court and allowed the cross objection filed by the defendant with regard to striking out paragraph number 16 and 17 of the judgment of the trial court, which was in favor of the plaintiff with regard to his possession. And since the suit is only for a bare injunction, the findings of the first appellate court striking out para number 16 and 17 and upholding the judgment of the trial court is perverse, illegal, and contrary to material evidence on record. On these grounds, Learned Counsel for the plaintiff submits that the matter requires consideration for framing the substantial question of law. And to set aside the error committed by both the courts. And he pleads this praise before the court to frame substantial question of law and consider the matter on merits. Full stop. Error. Per contra, learned counsel Sri B.S. Nagaraj, representing the defendant, vehemently contends that admittedly the defendants filed a writ petition in WP number 8497 of 83 and 18551 to 18558 of 1995, along with other land losers and siteless persons before this court, challenging the validity of allotment made by the MCC. It is also not in dispute that in the said writ petitions, the MCC filed a memo dated 6/8/86, undertaking to consider all these applications of the writ petitioners for allotment of sites within 3 months from the date of the order in the writ petition to those eligible land losers and siteless persons. And the writ petition came to be disposed of accordingly. Learned counsel for the defendant further contends that in pursuance to the order passed by the writ petition stated supra, the Standing Committee of Finance and Taxation of MCC took up the matter and decided to allot the site in favor of the defendant and other writ petitioners who are deprived of allotment of sites as they are the land losers and siteless persons. Thereafter, a resolution was passed allotting site measuring 30/40 in favor of the defendant, and he was directed to pay the allotment price, which was duly paid by the defendant, and the MCC issued a possession certificate to the defendant dated 6/4/95, along with the Khata endorsement, and collected the tax towards the said suit chattel property. It is borne from the records and the evidence adduced by parties that the MCC has cancelled the previous allotment of sites made in favor of the plaintiff and allotted the same in favor of the second defendant. Full stop. It is also a vehement contention put forth by learned counsel for defendant that the contention of the plaintiff cannot be taken for consideration for the simple fact that as on date of making the application for allotment of the site, the plaintiff was a minor, as the documents reveal that the plaintiff was born on 18/4/1966. And the application was filed. Yavag application hakiradu? As claimed, the application is made in the year 1978. 22. Yavag date idea? Somewhere during 1978. Therefore, he contends that the application per se is evident that as on date of making the application, the plaintiff was a minor and he could not have made such an application. Therefore, it is a concocted and fabricated document which is created for the purpose of filing this case. Council further contends that when the allotment, when the application for allotment itself depicts to have been concocted and fabricated, the question of allotment thereafter, if any made, would not stand the test of law, as any application made by way of fraud or concocted documents would stand void in the eye of law. Full stop. He further contends that pursuant to the allotment made by MCC wide Exhibit D1 in favor of the defendant and possession certificate and tax receipts having been produced along with Khata endorsements exhibits D2 to D5. It's apparently clear without ambiguity that the defendant is in peaceful possession, enjoyment of the suit schedule property in consonance and pursuance court in writ petition number 18 so and so stated supra. Hence, he contends that pursuant to issuance of exhibit D1 to D5, the question of plaintiff being in possession of the suit schedule property is far-fetched and imaginary, as any document prior to exhibit D1 to D5 and after the order of the writ court in the writ petition stated supra would not inure to the benefit of plaintiff, rather categorically confirms the title and possession of the suit schedule property in favor of defendant. These aspects have been correctly appreciated by the trial court as well as the first appellate court and has dismissed the suit of the plaintiff. So also the first appellate court has taken cognizance of the fact that there was an error committed by the trial court by adverting to the possession in para number 16 and 17 of the trial court judgment and rectify the same in the first appeal, holding that the plaintiff has created documents and is not in possession of the suit schedule property. Hence, the question of granting injunction against the true owner would not arise and rejected the suit filed by the plaintiff for permanent injunction. Full stop. On these grounds, learned counsel for the defendant contends that there is absolutely no illegality or perversity in the judgment passed by the first appellate court, trial court and the first appellate court. And so also the modification of the order of the trial court by the first appellate court in striking down para number 16 and 17 of the trial court judgment. He also contends that there is no substantial question of law that requires for consideration before this court, as the plaintiff has not filed the suit for declaration of his title and the suit is only for bare injunction. Full stop. Error. I have gone through the impugned judgment of the trial court and the first appellate court. And so also the original records of the trial court as well as the first appellate court. And on hearing the arguments of learned counsel for plaintiff and defendant, it is an admitted fact that initially the plaintiff was allotted the site by way of Akkupatra as per exhibit P1, and also he has paid certain tax and the revenue records stood in the name of the plaintiff for a brief time till the defendant and other land losers approached this court by filing writ petition stated supra to cancel the said illegal allotment and to allot sites to only those land losers and siteless persons who are eligible to be allotted in accordance to the notification issued by the MCC. It is also not in dispute that this court in writ petition 18551, 18558 of 95 and 8497 of 83 passed an order pursuant to the memo filed by the MCC that they would consider the applications of the writ petitioners for allotment of sites to the eligible persons and disposed of the writ petition accordingly. It is also not in dispute that the Mysore City Corporation Standing Committee for Finance and Taxation took up the matter thereafter and allotted the suit shuttle property in favor of defendant. Which defendant are you? Defendant number 2. Huh? Defendant number 2. Defendant number 2 alvenri. Katella beda defendant number 2 Australia. Defendant number 2. Therefore, these aspects have been considered in detail by the trial court as well as the first appellate court by taking into consideration the materials placed on record, both oral and documentary, and the evidence adduced by the parties and the judgment of the orders of this court in writ petition stated supra. Having considered all these aspects, the trial court dismissed the suit of the plaintiff. But however, in para number 16 held that the second defendant is not in possession of suit shuttle property, which came to be rectified by the first appellate court by striking down para number 16 and 17 of the trial court judgment by allowing the cross objection preferred by the defendant in the first appeal. And the first appellate court confirmed, dismissed the appeal and confirmed the judgment and decree passed by the trial court. Full stop. Though it is the vehement contention of learned counsel for the plaintiff that the trial court as well as the first appellate court have not taken into consideration all the materials on record and both the courts have committed an error in not taking into consideration the position established by the plaintiff by virtue of the documents placed on record. The judgments of both the courts are erroneous, illegal, and perverse. Therefore, calling for interference by this court by framing substantial question of law to consider the same and set aside the judgment of both the courts. Full stop. Having heard the learned counsel for the plaintiff and defendant in detail and having perused the judgments of both the courts and the submissions put forth, the scope under section 100 CPC for dealing with the second appeal matter is very narrow and limited. This court cannot consider the matter by trying to reappreciate and reanalyze the entire material evidence like a first appeal court by getting into the shoes of the first appellate court to reappreciate the material evidence on record, to arrive at a conclusion whether it is right or wrong and to take a different view, even if it is possible, on factual aspect of the matter. Section 100 of CPC deals with the consideration of substantial question of law, if at all that arises for consideration, and if made out by the appellant. It has to be in extraordinary circumstances that this court would interfere in second appeal dealing with matters pertaining to factual aspects and the evidentiary aspects which is not considered by the trial court and the first appellate. Unless such an anomaly has been pointed out and proved and satisfactory to this court would not interfere in the second appeal on a concurrent finding of fact by both the courts. Admittedly, the suit of the plaintiff is only for bare injunction, for a direction to the defendants not to interfere with his peaceful possession, enjoyment of the suitable property. Both the courts concurrently have come to a finding that the defendant is the absolute owner, having established his title and possession over the suitable property on the basis of materials placed on record. Therefore, I am of the opinion that the plaintiff has not made out any case for this court to frame any substantial question of law at this stage of admission. This court finds that this matter does not require for framing any substantial question of law. Accordingly, pass the following order. Appeal is dismissed as no question of law requires consideration. Ordered accordingly. In view of dismissal of this appeal, pending IA would not arise for consideration, same pales into insignificance. The judgment purpose. ಅವರು ಕೊಟ್ಟಿದ್ದಾರಾ? ನೀವು ಕೊಟ್ರಾ? Learned counsel Vinay has relied upon the judgment of The Honorable Apex Court in the case of 2007, Ramji Rai and another versus Jagdish Shonsu, reported in 2007-14. Which para you relied on? I think para number 9. Para number? Correct, correct. But that's the finding of fact. We do not wish to interfere on things.
It should not have been dismissed on ground that the title was not.
Suffice it to state that the lower appellate court should have dismissed the suit filed by the appellants only on the ground that the appellants had failed to prove that they were in possession of those disputed lands. Right. You're not so filed for title. You're not filed. Correct. The judgment relied by the learned counsel did not help the plaintiff. The simple reason that the suit filed by the plaintiff is for bare injunction. When a suit is filed for bare injunction, the fundamental requirement of law is that the plaintiff would have to show his possession in the suit scheduled property, a lawful possession in the suit scheduled property. The plaintiff cannot take the plea that the defendant would have to establish his possession or right over the suit scheduled property as the plaintiff has approached the court seeking for an order of permanent injunction on the basis of his possession. Howsoever the possession will have to be by way of a lawful or settled possession. The plaintiff having failed to establish the same, the present case, and the defendant on the contrary having proved his possession of the suit scheduled property by producing exhibits D1 to D5 on the basis of the orders passed by the writ court in the writ petition stated supra. The question of going into title would not arise as the plaintiff would have to establish his possession in the suit scheduled property as a lawful settled possession. In this view of the matter, both the courts having on factually coming to a conclusion that the plaintiff is not in possession, I do not find any ground for interference of the same, and no question of law is requires to be formulated for consideration. Accordingly, the same is negated. Yes. Why? Huh? Learned counsel seeks time release next week. Counsel for our respondent also present. relist this matter next week at request of appellant. You responded. Huh? ನೀವು ಇದೇ ಸೌಂಡ್ ಅಲ್ಲಿ ಮಾತಾಡೋದ ಹೊರಗಡೆನು ಕಾರಿಡಾರ್ ಅಲ್ಲಿ? ನೀವು ಇದೇ ಸೌಂಡ್ ಅಲ್ಲಿ ಮಾತಾಡ್ತೀರಾ ಕಾರಿಡಾರ್ ಅಲ್ಲೂ? ಕೇಳಿಸೋದೇ ಇಲ್ವಲ್ಲ ನಮ್ಗೆ, ಕೂತಿರೋರ್ಗೆ ಕೇಳಿಸಲ್ಲ ಪಕ್ಕದಲ್ಲಿ. ಹಾ, ತಲೆ ಆಡಿಸಿದ್ರೆ ಏನ್ರಿ? ಮೇಕ್ಸ್ ಅ ಸಬ್ಮಿಷನ್. No, the appeal is filed by whom? D4 and D5. New York. Plaintiff. So what is the concurrent finding? 1/8 share. What is the defendant 4 and 5 defense?
4 and 5 sense of police on the marriage of the daughters, some of they have property. On the marriage of the daughters, not
You are ready your papers, you are ready to argue. Or ಕೊಡೋಣ ಟೈಮ್. ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? You should start arguing when you will learn. ಅವ್ರು ಮಾಡ್ಲಿ. I will give you opportunity. You go and prepare your case and argue. Now that he is not here, I'll adjourn it. By then you prepare yourself and argue. You have two concurrent findings in your favor. Allah. And this is a good opportunity for you to argue. But called learned counsel for the appellant. There's no representation. Counsel for respondent 1 and 2 is present. 1 and 2, na? No representation for 3 to 6. Let's release this matter week after next. Read the papers, get ready and argue. Yes, Mr. Sharif.
the common judgment with or sitting on the court of the commissioner, then you can go. That's available in the report. Definitely not afford also that's by the case. It is this is of the two
Your appeal will not survive. ಹೌದಾ? ಎಲ್ಲಿದೆ? Kodimada, RS 1062. So both the suits are filed for the same property.
Then, question I want to say.
So now you are the defendant. So in the earlier suit, you are the plaintiff. So you challenge this. So this is it came to be dismissed. Okay, the order. Non-prosecution dismissal. Non-prosecution. So what do you want to do?
I will. Proceed.
That's equal. 2014 now. 2016 will dismiss.
In case is, I have also read one of it.
No, what is a suit filed by the plaintiff for use of road?
That one of could be in order to I was after that. And we are not using it. Our case, but independent is also responded, but also. Was very responding. So I have not it. The commissioner has said that there is no such release between the. This is rush to page 56. Page page 20. Release.
1 minute. So it was your case that there's a 3 feet to 50 feet gully. So that is negative. Anyway, what happened in the first appeal court? There is a factual aspect how this court can, what is it? Nothing survives. Just confirm it. Now you are using that, there is a, according to you, that gully is still there or not there? Commissioner was examined. Para 23. Read it.
For dependent legislative in lawyer property has restricted administrative power. The plaintiff has put up the report is sketch those cases existing. That is gully measuring 100 feet, 100 feet. Commission also has been admitted in his certificate. Salary party ಜಾಗದಲ್ಲಿ ಯಾವುದೇ ಗಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಪ್ರತಿವಾದಿಗಳು ಖಾಲಿ ಜಾಗ ಅಂತ ಬರೆದಿರುವ ಜಾಗದಲ್ಲಿ ಯಾವುದೇ ಗಲ್ಲಿಗಳು ಬರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗಳಿಗೆ ಸೇರಿದ ಮಂಗಳೂರು ಎಷ್ಟು ಮನೆಯಿಂದ ಹಿಂಭಾಗದಲ್ಲಿ ತಪ್ಪನೆ.
Read further 24.
The commissioner himself has reported that towards the west of no gully or space is existing. The plaintiff has restricted asbestos sheet adjacent to the set wall, and the commissioner is in his report has not mentioned the measurement and the properties of the plaintiff and individual. He has only reported that what is the actual situation of the property of the plaintiff. The commissioner also admitted that good expectation of the he has reported that both the existing depending on the existing will not go to depending on all the commission has clearly no existing will be categorically it is a 1.5 feet. Beginning has produced the negative mark of E788. Therefore, are not very good. Then ultimately, the different property is on this one is existing and different property and different and no value is existing towards each service that was
The suit was only for bare injunction. Bakkalam. Lord Leonard Counsel Shri Kalimullah Sharif, on behalf of appellant. Stop. This appeal is preferred by defendant number 1, being aggrieved by the judgment decree in RA number 67 of 2007, dated 30th April 2014, passed by the learned senior civil judge and CGM Chamarajanagar, dismissing the appeal of the defendant number 1, consequently confirming the judgment and decree in OS number 140 of 2003, dated 21/4/2007, decreeing the suit filed by the defendant and granting permanent injunction in favor of the plaintiff. Please stop. The facts of the case. Party shall be referred to as per the status before and ranking before the trial court. Plaintiff filed original suit in OS number 140 of 2003 before the Principal Civil Judge, Junior Division, JMFC Chamarajanagar, the relief of declaration of permanent, for the relief of decree of permanent injunction against the defendant. And simultaneously, the defendant also filed a suit for permanent injunction against the plaintiff in OS number 218 of 2002. Both the suits were clubbed together and common evidence was recorded and disposed of by a quite common judgment. The suit preferred by the plaintiff in OS 140 of 2003 came to be decreed, and the suit preferred in OS number 218 of 2002 by the appellant herein came to be dismissed. The facts are as under. One Rachappa, son of Ningappa, applied to the then Amaldar Chamarajanagar for grant of site by the side of survey number 170 and 171 of Madhapura village, Chamarajanagar Taluk. As said, Rachappa was residing in the said site. Full stop. The then Amaldar of Chamarajanagar Taluk was pleased to direct Ningappa, son of Rachappa, to deposit ₹6 and 15 paise and pay the land revenue for a period of 50 years, amounting to ₹9 and 11 paise. Thereafter, said Lingappa, amount was paid on 30th June 1948. Due to the interference of the appellant defendant herein, number one herein, a suit came to be filed by the plaintiff in OS number 140 of 2003. In the earlier suit filed by the defendant number one, who was a plaintiff in OS number 218 of 2002, it was alleged that there's a common gully measuring east to west 3 feet and north to south 50 feet. Whereas the plaintiffs took up the plea that the defendants, without any manner of right, title, or interest, is unnecessarily interfering with the peaceful possession and enjoyment of the plaintiff over the suit schedule property. It is also the contention taken by the plaintiff that there is no gully as alleged by the defendant number one, and filed a detailed written statement in the suit preferred by the defendant number one in OS number 218 of 2002. Both the suits admittedly came to be filed by the respective parties for permanent injunction against each other. Based on the pleadings of the parties in both the suits, the trial court framed the following issues for consideration. Page number 63, in 62 or 63 there, that's more clear. So page 63 issues are there. Huh? Internal para 7 of the judgment of OS. Based on the pleadings, the trial, upon the not for the strike of money, in order to substantiate the claim, the plaintiff number one examined herself as PW1 and two other witnesses PW2 and 3 and got marked exhibit P1 to P8. Whereas the defendant number 1 and 2 examined themselves as DW1 and 2 and two other witnesses as DW3 and 4 and got marked exhibit D1 to D8. A court commissioner was also examined as CW1 and he got marked C1 to C6. Full stop. Based on the evidence adduced by the parties, the trial court, after consideration of the same and on careful perusal of the materials on record, including the court commissioner's report and the documents placed by the CW1 court commissioner, agreed with the plaintiffs in OS number 140 of 2003 and granted a decree in OS number 140 of 2003 by restraining the defendants from interfering with the peaceful possession and enjoyment of the plaintiff over the suit schedule property. Consequently, the suit in OS number 218 of 2002 referred by the present appellant came to be dismissed. Agreed by the judgment and decree passed by the trial court in both the original suits. The appellant herein preferred two appeals. General ನೀವೇ ಅಲ್ಲ appellant. Both the appeals were taken up together for consideration as common judgment was passed by the trial court. And the sum and substance and the arguments in both the appeals were common. Therefore, the appeals were taken up together, and being not satisfied with the contentions put forth by the appellant in the first appeal, before the first appeal, the appeal came to be, both the appeals came to be dismissed. And the order, the judgment and decree passed by the trial court in both the suits came to be affirmed. Full stop. Agreed by the judgment and decree of concurrent finding of both the courts, the appellant referred to second appeals. The present appeal, the appellant was the defendant number 1 before the trial court in OS number 140 of 2003. Another appeal came to be filed in RSA 1062 of 2014, wherein the appellant herein was the plaintiff in OS number 218 of 2002. Which also came to be dismissed by a common judgment. It is relevant to mention on the order sheet in 1062 that the appeal preferred by the appellant here in RSA 1062 of 2014 came to be dismissed for non-prosecution while order dated 29 August 2016, and the same as attained finality as no challenge is made and no order for recalling is filed till date. Full stop. The appellant herein, who is the defendant number 1 in the original suit OS number 140 of 2003, contends before this court that the judgment and decree passed by the trial court and the first appellate court is illegal, perverse, and contrary to the material evidence placed on record. Hence, this same requires to be set aside and reversed, as the trial court and the first appellate court have not considered the evidence placed on record, including that of the court commissioner appointed by the court. is further contended by the counsel for the appellant defendant number 1. That there exists a gully measuring to an extent of 3 feet by 50 feet, which has been conveniently ignored by the court. Which is illegal and perverse, and hence, for non-appreciation of the material evidence on record, including the Commissioner's report, he seeks that a substantial question of law requires to be framed for consideration to set aside the judgment of the trial court as well as the first appellate court. I have heard learned counsel for the appellant and having perused the impugned judgment of the trial court and the first appellate court. It is apparently evident from the records that both the suits were filed by the respective parties for the relief of permanent injunction. Restraining each other from interfering with the peaceful possession and enjoyment of their respective portions of the suitable property. It is the case of defendant number 1, the appellant herein, that there exists 3 feet passage, which is a common gully, east to west and 50 feet north to south. On the area which the defendant number 1 is seeking for an order of permanent injunction, restraining the plaintiff from using the same. But the suit of the appellant herein in OS number 218 of 2002 came to be dismissed, and the first appellate court confirmed the same, which came to be affirmed, which in the second appeal came to be dismissed due to non-prosecution. So therefore, the same would have a bearing on this appeal, as the order in OS number 218 of 2002, wherein the appellant herein was the plaintiff, has attained finality, and the same is not challenged. Full stop. Even otherwise, the trial court has considered the material evidence on factual issues put forth by both the parties before the trial court as plaintiffs in each of the suit. And after adverting to the material evidence placed on record and the documents relied by both the parties, has come to a finding of fact that there does not exist any common passage or common gully measuring to an extent of 3 feet and east to west and 50 feet north to south. And accordingly, the suit preferred by the plaintiff in OS 140 came to be decreed, restraining the defendant number 1, the appellant, appellant herein, from interfering with the peaceful possession enjoyment of the plaintiff over the property. The Commissioner CW1's report was also taken into consideration, and accordingly, a common judgment was passed. The appellant being aggrieved by the said common judgment in the original suits preferred and first appeal, which came to be dismissed, confirming the judgment and decree passed by the trial court. Full stop. In the second appeal before this court, the appellant defendant number one is seeking to set aside the concurrent finding of fact arrived at both the trial court and the first appellate court. To reverse the finding of fact on the ground that both the courts have not considered material evidence on record and ignored the documents placed and exhibits on record, and also for having not considered the evidence adduced by the commissioner, court commissioner. Full stop. However, on perusal of the records and the imputed judgment of both the trial court and the first appellate court, it is evident from the records that the trial court as well as the first appellate court has considered all the material evidence on record, both oral and documentary, including the evidence adduced by the court commissioner and the documents placed by him in exhibits C1 to C6, and passed an order in favor of the plaintiff and against the defendant number one herein, against the defendant number one, by granting an order of permanent injunction. Full stop. While considering the second appeal under section 100 of CPC, this court generally would not interfere in the concurrent finding of fact arrived at both the courts unless there is gross error or perversity committed by the trial court as well as the first appellate court, or by ignoring the material evidence placed by the parties. This court will have to be circumspect in venturing into giving a finding on the factual aspects, while both the trial court and the first appellate court have already decided the factual scenarios on the basis of material evidence placed by both the parties. Under section 100 of CPC, it is only the substantial question of law that is required to be considered by this court, and not venture into the factual aspect of any additional material that is placed before the court subsequent to the orders passed by the trial court and the first appellate court. Full stop para. It is also relevant to note that the appellant herein, who was the plaintiff in OS number 218 of 2002, having suffered an order of dismissal of his suit, having questioned the same before the first appellate court and the same having been dismissed, confirming the judgment of the trial court, was challenged before this court in RSA number 1062 of 2014, was dismissed for non-prosecution on 29th August 2016. Having attained a finality, nothing much would survive in the present case, as the subject matter of the dispute is one and the same. Full stop. Even otherwise, learned counsel is unable, the learned counsel though has argued to allow the appeal for framing substantial question of law. In my humble opinion, nothing is made out to consider substantial question of law to be framed by this court to entertain this second appeal at the stage of admission itself. Under the circumstances, there being no merits and no substantial question of law having been brought forward for consideration before this court, this appeal does not deserve to be admitted to frame question of law, substantial question of law. Under the circumstances, in view of the discussions made herein above, I pass the following order. Appeal is dismissed. You argued partly. ಅವ್ರು ಮಾಡಿದಾರ ನೀವು ಮಾಡಿದಾರ? You are going. For whom? What about others?
ಅದೇ
That is his case. But others are also not coming. I will dismiss it. I will dismiss it for default. Yes. Yes. Yes.
On the basis on immediately. That the president does not declare. When the review is found out for the court making a conduct.
Yes. No, that cannot be. 41 rule 70. See, once a matter is admitted, you have to dismiss it either on merits or for default. Correct. So that will not arise now. I have already marked it in my book. For default only. If at all they come. It appears they are not interested in. Suit for what? This is filed by whom?
By the respondents.
Defendants, sir. Learned counsel for appellant number 1 is present before the court, but again expresses his inability to proceed with the matter as there is no instructions from his client. For representation on behalf of other appellants, namely appellant number 2 and 3. Learned counsel for respondent number 1 is present, who is ready to go on with the matter. And sir, in order to provide one more opportunity, call this matter in the post-lunch session. We'll call it after lunch. You already sent letter to your client. We'll dismiss it for non-prosecution. If his client doesn't come, what he can do? No, but I am wondering why the others are not appearing. The waste of time again. Because anyway, this court is not considering it on merits. When they file application, that time we'll see.
Court officer. Court officer. Serial number 34.
Yes, sir.
ಅದೇನ್ ಮಧ್ಯಾಹ್ನ ನಡೀತದೆ 2:30ಗೆ?
ಜನ 2:30 ಒಂದು ಮ್ಯಾಟರ್ ಇದೆ, ಪಾಸ್ ಓವರ್ ಇದೆ. ಮೆನ್ಷನಿಂಗ್ ಬೇಕಂದ್ರೆ ಬಂದ ತಕ್ಷಣ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು.
ಎರಡು ಬೇಡ ಕೊಟ್ಟಿದೀವಿ. ಎರಡು ಬೇಡ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಬೇಡ. Family members. Purchaser. Both the parties are present. Request of land council for the appellant and also council for respondents R1, 2, 1 and 2 in bracket A to C. It appears that there is some proposal for settlement to amicably resolve the issue. Parties are also present before the court. Since counsel for the respondent seeks time to report settlement. When do you want particular take a date? Take a date and report settlement on that. We list on 27th. On that day, you report settlement, whether if it's happened or not happened.
What is this?
This is the application form. Serial number is it?
21.
You 1 of 17. You follow. Still pending. Other than apart from there is this 9617.
It's the others. Hierarchy.
But there's no representation. Call out the name of the council.
21 Babu.
There's no representation on behalf of appellant. So also on behalf of respondents. On behalf of appellant, sir. It is seen from the notings in the order sheet. IA number 1 of 14 has been filed for recalling the order dated 11/4/2014. Wherein this court dismissed the appeal. Due to non-compliance of the objections raised by registry. Full stop. Thereafter, the application came to be filed for recalling the said order. During the pendency of the said application, another order came to be passed on 9/6/2017 by this court, dismissing the appeal with respect to respondents number R1A and R1C due to non-taking of steps to bring the LRs on record. Full stop. IA number 1 of 17 is filed to recall this order of 9/6/2017 by the appellant. Thereafter, the matter has been called on 7/2/2020. And it is again listed today. But there is no representation on behalf of the appellant. It is borne from the records that the appeal has been dismissed way back on 11th April 2014, which is not yet recalled. And despite filing the application for recalling, the counsel, there's no representation on behalf of appellant. This matter was called out in the morning session. There's no representation on behalf of appellant. Counsel for respondent was present. This matter is called out again at 2:45 p.m. There's no representation on behalf of appellant. It appears that the appellant is not interested in prosecuting the matter. In view of the same, the application IA number 1 of 14 and IA number 2 of 17. 1 of 17. 1 of 17 and 2 of 17. 1 of 14 also is recalling the order. I changed. And 1 of 14 are hereby dismissed for non-prosecution. Consequently, the appeal is dismissed. Your counterparts have not come. That's learned counsel for the appellant number 1 is present. So also learned counsel for respondent number 1. Counsel for appellant number 1. Appellant 1 submits that he has no instructions to proceed further in the matter. And he has written a letter, a legal notice to his client, provide instructions failing which he would retire from the case. The submission was made twice earlier before this court, just been noted in the order sheet of this court. It is also seen that there is no representation on behalf of appellant number 2 and 3 consecutively for several dates of hearing, despite this court giving an opportunity for them to appear before the court and address their arguments. Counsel for respondent number 1 is present. This matter was called out in the morning session. There was no representation on behalf of appellant number 2 and 3, except for appellant number 1, who again expressed his inability to proceed further in the matter due to no instructions to proceed further in the matter. This matter is submitted to consider substantial question of law. But due to the non-appearance of appellants, counsel for appellants, this has been dragged on for several dates of hearing, but heading nowhere. Hence, it appears that the appellants are not interested in prosecuting the matter. Accordingly, appeal is dismissed for non-prosecution. Both appeals, same one. Both appeals.
Serial number 34, I am ready, my lord.
This is serial number 56, sir. 56. 34 line, 56.
Yes, yes.
What is this matter, Mr. Holla? Correct. That would be useful. Page 24. Yes, yes. Yeah, that Jodhpur Indians. Yes, there are one. So fundamentally, you are now saying that only for that period. Otherwise, for all other periods, it is not restricted. It has kept it open. Yes.
I not compared 128 before that Roman 1.
Yes.
To avoid 3 lines about that.
Yes.
Structure is including the structure.
One-time measure. One-time measure.
Yes.
Yes.
And this honorable court on during 2021 that COVID period, page 70.
Yes.
And what is running page 90.
Yes.
School management concern order. Private institutions collect annual fee from their students and in 99 act of 99 for the but by providing reduction of 50% amount, you have unutilized. Not their basket. Other order.
Yes.
Therefore, they are saying, it might not come about page 22 water.
Yes.
2021.
Yes.
They are saying not all. Daily university ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ರಾಜ್ಯದ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಖಾಸಗಿ ಶಾಲೆಗಳಲ್ಲಿ 2021ನೇ ಶೈಕ್ಷಣಿಕ ಸಾಲಿನ ಅನ್ವಯವಾಗುವುದು ರಾಜ್ಯ ಪಠ್ಯಕ್ರಮ ಸಿಬಿಎಸ್ಇ ಬಿಸಿಎಸ್ಇ ಇದರ ಪಠ್ಯಕ್ರಮದ ಶಾಲೆಗಳು ಸೇರಿದಂತೆ ಆತಂಕ ಮಾಡಿದ ವಿದ್ಯಾರ್ಥಿಗಳ ಘೋಷಣೆಯಿಂದ 2021ನೇ ಶೈಕ್ಷಣಿಕ ಸಾಲಿನಲ್ಲಿ ಬೋಧನಾ that is tuition fee. What they say is tuition fee will collect only 70%. Not annual fee. Annual fee is something more than the tuition fee. Tuition fee one. There are other components. This not to what brought in the Senate citizen at page 93.
Yes.
Specifically said for 15% of the annual fee. You are get the third line there.
Correct.
Now, if you just come back to page 20. They are saying, no, I can only about 85% of the tuition fee. That's what is essentially important. 70%. 70%.
So now they say 70% of tuition fee.
Tuition fee. Only that much, nothing else can speak out on that.
Yes.
How they should Trust society, nothing is here. But there are so many other
Correct. Components.
so essay. That is not not essay.
So, but what they have restricted is this is for 2021.
But then when industry not like one not be it cannot be not better. In fact, we are all for ICSC or PBSC schools. IC and CBSC. It does not apply to other topics. Anyway, we have not given them this 85%, not 50% concession annual. If you are the order is, if you are collect only tuition, it will be 70%, nothing more.
So it has to be totally that 80% what is ordered as a one-time measure. So that will apply to you also. And that, but that will be again to annual fee and not the tuition fee.
So that's the short.
Oh. Yes, Mr. Naik, you are also along with him in the same point? Yes. 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 Amount 23866. February. Production of some orders. Yeah. Yes. I have it.
60 twice. Earlier on currently on the of it did not integrate in the operative portion. The declaration of reasonable code that it is not compatible with the minimum. Once there is why we have already found that the intervention is contained in the actual part of the order, in the operating portion. It must be order. This one will examine the various and the richest now.
Yes, sir. Yes. 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 Continues to pass orders. So if that order was quashed in the earlier proceedings, probably this would not have arisen. Yes. All.
Para one states under order 21/1/2021 and permitted conditions. Para two, state order being the back of the COVID was passed. The company so and votes except and extracts seven of the courts operated portion of the order of 16/9/2020 and refers to the communication. Primary education requesting for disputes of directions for implementation of the order for order of 16/9/2021. But revising the reduction of PPP. Other three is stated, examining the state proposal and the order of 16/9/2021. The government order is either passed, is the new order. In other words, the new order seeks to revise the earlier government order, 21/21, in the light of the which permits collection of 85% further seeks to delay and prohibit review of any other fees by private schools management further condition. Full fees are paid. Vice the earlier order, it has been declared.
Review of that earlier order of his lordship gave us. Correct. Yes.
It's not about notice. It's rather than decision for order. State government has issued one more governing order. Still implement and deliver process faster. The councils which will be strong and ready. State government will not have. State government. Consequently,
What? Yes. Yes.
Then indicated with more. Sense of research. State has limited power. Every time advises by order. Watching of this is on order norms. Influence and they would provide for promises of merely what the game is basically is a factory and significantly order to the online report. The input of the small soft Because of implementing the order of
This is a third round. I think I'm hearing it for third. I had not passed the order. No, nothing. I think you cannot go beyond already what the additional advocate general is. No, but for your information, maybe you are not here. This was heard in full. It was only reserved for me to pass orders. I could not do it due to my paucity of time. But nothing remains on your side. But nevertheless, you can take a day or two and make your submission, because like what the senior counsel submitted, it will probably should go on the basis of the Jodhpur school, because that is what is the considered. So the impure order will have to go. That's all. Just. No, now you cannot go back on that. Already the judgment passed by coordinate bench of this court wherein it is passed on the basis of the concession and acceptance of learned additional advocate general. Only flaw was there, probably the mishap happened was that in the operative portion, it was not quashed. Now that in the review, it is quashed. Nothing survives for the government to make now fresh orders every now and then.
Sir, very problem.
I think Supreme Court has said that the private management has got their own. Thereby, it will not survive anymore. Anyway, I'll grant you 2 days time. Heard for the learned senior counsel, Sri Uday Holla, on behalf of Farah Fatima, for the petitioner, and learned counsel, senior counsel, Sri Madhusudan Naik, on behalf of Pawan Shyam, Anuparna Bardoli, and learned AGA, which present before the court, seeks a short accommodation and release this matter. Yes, madam. Friday, I may not be sitting, traveling Friday and Monday. First, yes, I think both of you have completely. Thursday, madam. Released on Thursday, 14th. Yeah, no problem. I'm sorry. In fact, I should have passed the order. I think you have argued in the council. No, I have noted down. In fact, I have read through the file, and whatever you said, I have read through the entire submissions of both, and it's marked also in red by me. Only thing I could not find time to pass the judgment. Thank you. File has to be kept. File has to be kept with me for just reading once again. Yes. ನಿಮ್ದಾಗಿದೆ ಅಲ್ಲ, you have completed. ನೀವೇನಾರ ಹೇಳಾಗಿದ್ರೆ you can submit. You have finished? And let him come, we'll wait. Synopsis ಕೊಟ್ಟಿದ್ದೀರಾ? Password.
Number 34, select from Nahru.
Said he was ready. ಪಾಠ ಆಗಿಲ್ಲ ಆಗಿದೆ. MFA. MFA ಇದೆ. All right, you tell him to come. Feel ಕೊಡಿ ಮಾ. We see him. January 23. Krishna Swami, R2. ಇವರು ಇದು ಇವ್ರು ಬಂದ್ರು ಅಜಯ್ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತಾರೆ CM ನಾಗಭೂಷಣ್ Senate counsel for the appellants each time on the ground of bereavement in the family of the counsel for appellant. Let's release this matter next week. Huh? 21st. 21st is okay. Pegoda. What's over?
Nine, 1 hour.
What's over?
Serial number 34, I am ready, my lord.
Yes, Mr. Latur.
Yes, my lord.
So you
Yes,
are the
sir.
rider of the motorcycle.
Yes, my lord. The rider of the motorcycle.
The compensation is granted.
Yes, my lord. Compensation is granted 1,50,060 rupees, my lord. Here in this case, my lord, the meager compensation has been awarded by the Honorable Tribunal. The accident has taken place on 22/7/2012, my lord. Then he was riding a moped TVS, my lord. Then car came and dashed against the his motorcycle. As a result, he has sustained the fracture of left tibial condyle and Schedul's type V fracture, my lord, and multiple fracture with PTRA to the left foot. And he was inpatient in a hospital for about 1 month, 5 days, my lord. He has been operated and ultimately he has become disabled to the extent of 54% of the limb, my lord, and left limb, and 27% whole body, my lord. So here in this case, my lord, the Honorable Tribunal has taken the income, only 4,000 as a notional income, my lord. In the year 2012, as per the chart, my lord, it has to be taken 7,000 rupees.
The chart again. Yes, 7,000 is the chart.
The income has to be enhanced to the extent of 7,000 rupees. And with regard to the injury sustained by the petitioner, your my lord,
two grievous injuries has been sustained by the petitioner, and he has been operated also, and award has been made only 40,000 for the injury, pain and suffering, my lord. So it has to be enhanced, my lord. And also in this case, my lord, the loss of amenities has not awarded by the tribunal. And another head, my lord, food attendance, conveyance, this head also has not been awarded by the tribunal, my lord. And future medical expenditure is also not awarded, my lord, in this case. All these head has to be awarded. And with regard to the Your Lordship may kindly.
How many
see
days you are inpatient?
1 month for 5 days, my lord. My lord, in this case, he is a professionally, my lord, is a agricultural coolie, my lord. As per the evidence of the doctor, PW3, my lord, the PW3, he cannot do the manual or physical work, my lord. He cannot do the manual or physical work. So the relevant para of the judgment, my lord, with regard to the quantum of compensation, page 13, para 16, my lord.
Page
13, para 16, my lord. So here, my lord, injury, pain, and suffering has been explained by the observed by the honorable tribunal. Age is 62 years as per the evidence, because in the wound certificate it has been mentioned as 62 years that has been taken by the tribunal, my lord. Para number 18, it has been taken, though the petitioner has stated in his evidence that he was earning rupees 9,000 per month as per para 18, my lord. So the honorable tribunal, there is no proof of income.
all right, that 4,000 will make it 7,000 further.
Yes, that's all, my lord. And with regard to the injury, pain and suffering has been awarded by the tribunal is also a meager compensation. It has to be enhanced, my lord. Here in para number 21, the evidence of a doctor is here, my lord.
So you are inpatient. What is the injury you have suffered? Doctor has given statement.
Yes, my lord. Doctor has para number 21 of that judgment, my lord. Apart from this evidence, the petitioner is also examined. Dr. S.A. Somsekar, orthopedic surgeon at Boring Hospital, who treated the petitioner, and he has produced OP slip, IP records, X-rays, CC of sketch and CT scan film, exhibit P15 to 18, and he has deposed about the injuries sustained by the petitioner, treatment undergone and disability suffered by him. When the petitioner was subjected for his clinical and radiological examination, he found difficulties faced by the petitioner and assessed the disability of the left lower limb at 54% and 27% to the whole body.
Paperweight. All right. So he has given 27% to whole body.
Yes, my lord. 27% has been accepted by the honorable tribunal, my lord. Accordingly, I pray for this honorable court to the extent of 27% may kindly be awarded as a loss of earning capacity.
ಅದು ಕೊಟ್ಟಿದಾರಲ್ಲ.
ಅವರು 4,000 ಹಿಡಿದು ಕೊಟ್ಟಿದ್ದಾರೆ.
57% is given. Only thing that requires to be modified is from 4,000.
Yes, my lord. Here, ನಮಗೆ 7,000 ಹಿಡಿದು ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ, ಮತ್ತಿನ್ನೇನಿಲ್ಲ. ಅದು ಒಂದು. In other heads, in which the honorable tribunal has not awarded the compensation,
Medical treatment, 8,000
Yes.
rupees given.
Only 8,000 rupees has been loss of earning medical during medical treatment, my lord, as awarded. So it has to be enhanced at least for the 4 months, my lord. Looking to the nature of injury and also the disability sustained by the loss of earning during the period of treatment has to be enhanced for 4 months, my lord. 28,000 rupees.
What is the disability? What is the injury you have suffered?
He has suffered fracture of left tibia, my lord, condyle, tibia condyle, and multiple fracture with PTRA to the left foot. Crush injury is there, my lord, left foot. Therefore, here it is page 14 para 19, my lord. So far as injuries are concerned. Page 14 para 19.
I don't know this. Read that.
Yes, my lord. According to the petitioner, he had sustained grievous injuries in the accident. Therefore, he has undergone treatment during which he had suffered injury, pain, and suffering. On looking to the exhibit P8, wound certificate, and exhibit P9, discharge summary, OPD slips, photos with negative at exhibit P10 and exhibit P11, OP slip, IP records, X-rays at exhibit P15 to 70, P17, and CT scan film at exhibit P19, it reveals that the petitioner had sustained a Skechers type V fracture tibial condyle left.
All right.
And PTRA on left dorsum foot. Yes, my lord. And your lordship may kindly see the exhibit P11, wherein it is a photographs has been given. Photographs of the petitioner has been given, my lord. How much disability he has sustained and how much it has been disfigured, my lord. And exhibit P11. Exhibit P11, my lord. Photograph.
All right.
Your lordship. Left leg, my lord.
Yes.
So, my lord, in this case, the petitioner has become so disabled, he cannot do any work. So, under such circumstances, I pray for this honorable court, just and reasonable compensation has to be awarded. There are some decisions I am relying upon. In such a type of cases, the honorable our own High Court has allowed the case, my lord, 2017 ACJ 1065. Wherein, my lord, the honorable our own High Court division bench. In this case, the honorable High Court has observed that there is a injured suffered fracture of left side ribs, fracture midshaft of left humerus, upper end of radius and ulna, fracture of right pubic bone and left iliac bone. Injured remained hospitalized in different hospitals for about 6 months and underwent several surgeries. Injured aged 36, homemaker and agriculturist, owning 35 acres of land, earning rupees 40,000 per month, suffered 45% disability towards left upper limb and 15% towards whole body. Injured has to live with disability for rest of his life and he cannot do the work he was doing earlier to the accident. Tribunal, considering that income from agricultural continues even in absence of injured, assessed the loss of supervisory charges 4,500 per month, took disability at 30% and awarded 11,77,000. Appellate court assessed income at rupees 4,500 per month, adopted multiplier of 15 and taking whole body disability at 50%. Though there is a disability of 45%, my lord, honorable our own High Court has taken 50% the whole body disability and allowed 4,05,000 for loss of earning capacity, plus 1,50,000 for pain and suffering, 2 lakh for the loss of amenities and enjoyment of life on account of disability. 5,69,000 towards medical expenditure, 54,000 for loss of income during treatment period, 50,000 towards future medical expenses, and 75,000 for conveyance, nourishment, food and attendance charges. Award of rupees 11,77,000 enhanced to.
Evidence adduced by the doctor with regard to future medical expense.
Yes, madam. Here, there is an evidence of doctor also. I will read that evidence. PW3, my lord. PW3.
Read it.
Yes, my lord. On page number 2, on examination, he walks with pain and limping using bilateral axillary crutches. Even at the time of examination, my lord. So he was wasting of the left lower limb and swelling and deformity of left foot, discharging sinus in present over the dorsum of left foot, my lord. His recent X-ray shows united fracture tibial condylar with implants in situ, malunited fracture of the mid-tarsal and metatarsal bones of left foot with signs of infection, my lord.
Now, what
So
is the
yes,
statement of the doctor
yes,
with
my lord.
regard to future medical expenses requirement?
Yes, my lord. Here, page number 3, my lord. Page number 3 of the evidence. I put the total disability of the left lower limb at 54% and that of the whole body at 27%. In view of these disabilities, it is difficult for the patient to work as an agricultural coolie and difficult for him to do any other manual or physical work. He needs separate surgery for implant removal and control of infection of left foot, which would cost around 50,000 in a private setup, my lord. So, my lord, here the petitioner has become so disabled, and even in case of his future treatment also, as per the evidence of the doctor, 50,000 rupees he has to spend for the medical expenditure, future medical expenditure. But the tribunal has awarded
Any medical bills? Have you produced?
Medical bills. Yes, I have produced the medical bills to the extent of 38,072 rupees, my lord.
Kotilwa?
Kotidar, sir. Adin Kotidar.
Film share, let him complete. What are you arguing first time in High Court? Let him complete, you will get your chance. Yes.
Yes, my lord.
That amount is considered.
Yes, considered, my lord. Here, only 8,000 has awarded, my lord, for the medical expenditure.
Where is the bills? What are the exhibits?
I will give that to you.
38,072, exhibit P12 ತೆಗೀರಿ.
Exhibit P12, medical bill. 41 medical bills have been produced.
Exhibit P12. Consolidated bill inventory. Yes, are you agreeing with this 38,072 medical bills which he has produced, exhibit P12? Where is the finding of the tribunal with regard to this exhibit P12?
Exhibit P12, my lord, is at page number 17, para 24 of the decision, my lord. Here,
What
the
happened to
Honorable Tribunal accepted the pleadings of the respondent number 1 that he has paid the medical expenditure, my lord.
Huh?
That the respondent number 1 has pleaded that he has,
Yes, paid.
yes, my paid and
RWN has said that he
yes,
paid
ma'am.
1,000 towards, that will go.
Yes,
That will
ma'am.
get disconnected from that, deducted from that.
Yes, it has been deducted, my lord.
You can't claim that. Yes, what is your argument?
My future medical expenditure has not given.
All right, you have finished. Let me hear the other side. Yes.
Yes, madam. Yes.
You talk on the mic so that he can hear you. There's no dispute that he's 65 years, 62 years. Multiplication is number 7.
Yes, 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 madam. That is correct.
Future prospect ಎಲ್ರಿ ಬರುತ್ತೆ ಇದರಲ್ಲಿ. ಅದನ್ನೇ ತಗೊಳ್ತಾ ಇರೋದು. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಯಾವ ಕೇಸಲ್ಲಿ ಬರುತ್ತೆ?
Future prospectus, I am not claiming, my lord.
You wanted to argue very urgently. He is not claiming and you are arguing about future prospect. Future prospect ಯಾವ ಕೇಸಲ್ಲಿ ಬರುತ್ತೆ? ಡೆತ್ ಕೇಸಲ್ಲಿ. ಡೆತ್ ಆಗಿದೆ.
Even injury cases also, it will come because it is the age of 62.
All right, hear the order now. This appeal is preferred by the claimants. Being aggrieved by the judgment, an award passed by the MACT within brackets SCCH, MACT Motor Accident Claim Tribunal within bracket SCCH 13, in MVC number 7359 of 2012 dated 3/2/2014. MACT Pagdal for short tribunal. The claimant is before this court seeking enhancement of compensation, not being satisfied with the inadequate and meager compensation awarded by the tribunal. Party shall be referred to as per the status before the tribunal. Full stop. Brief facts of the case. On 22/7/2012, please sit down. At about 3 p.m., while the petitioner was proceeding on his, riding his TVS moped, vehicle bearing number KA05HI 9344 on NH7 near Doddapalya Gurki village gate, Chikballapura Taluk. At that time, the driver of a car bearing KA01 MG 2385 came from the opposite direction in a high-speed, rash and negligent manner, so as to endanger human life and safety, and dashed against the claimant who was riding the TVS moped along with a pillion rider. Full stop. Due to the impact of the car with the TVS moped ridden by the petitioner, the petitioner along with the pillion rider suffered severe grievous injuries, and they had to take medical treatment, thereby spending huge amount on medical expenditure. Full stop. The claimant is stated to be an agriculturist by profession, and he was aged about 62 years as on date of occurrence of the accident, which was caused due to the negligence of the driver of the offending vehicle, the car. Full stop. It also pleaded and claimed that the claimant was earning rupees 9,000 per month towards agricultural income. And in view of the sudden and unfortunate accident which has crippled his life, and having sustained a disability due to the negligence caused by the respondent, by the driver of the vehicle, he has lost his earning capacity, and therefore the future earning capacity of the petitioner claimant has been dented and diminished. Full stop. In view of the financial loss and the physical injury and mental emotional stress caused due to the accident by the driver of the offending car, the claimant filed a claim petition claiming compensation for the injury sustained and loss of future income. Stop. On service of notice to the respondents, number 1 and 2, who are none other than the owner of the offending vehicle and the insurance company, the respondents filed the written statement of objections disputing the accident and the occurrence of accident, involvement of vehicle, and that the accident occurred due to the rashness and negligence of the driver of the offending car. However, the respondents admitted the policy having been taken for the vehicle involved in the accident. But disputed the amount of compensation, including the income of the claimant. We'll stop there. On the basis of pleadings, the tribunal framed relevant issues for consideration. We'll stop. In order to substantiate the issue and establish the case, the claimant examined himself as PW2 along with the pillion rider as PW1, produced and also got to examine doctor as PW3 and got marked exhibits P1 to P18 together along with the pillion rider in the connected case in MVC number 7358 of 2012. Full stop. On the basis of material evidence, both oral and documentary, considering the evidence of PWs 1, 2, and 3, and the evidence and the exhibits P1 to P18 and the evidence of respondent RW1 and exhibits R1 to R5. The tribunal partly allowed the claim petition of the claimant and awarded total compensation of 1,50,060 rupees together with interest at 6% per annum, and directed respondents number 1 and 2 jointly and severally to pay the compensation, and also directed the second respondent insurance company to deposit the compensation within 2 months from the date of the order. Full stop. Para. Being dissatisfied with the meager and inadequate compensation awarded by the tribunal, the claimant is before this court challenging the same, seeking enhancement of compensation on various grounds. Full stop. Para. It is a vehement contention of learned counsel for the appellant claimant that the tribunal has not awarded suitable compensation and has not taken into consideration material evidence placed on record, including exhibits which are marked as exhibit P1 to P18. Full stop. He further contends that the tribunal has not taken the correct income for calculation for awarding compensation in the road traffic accident case. Full stop. It is further contended that the tribunal has failed to take into consideration the loss of income during the later period and the future medical treatment be incurred by the claimant, which is narrated by PW3 in his evidence, PW3 doctor in his evidence. He further contends that the tribunal has also not awarded amounts towards amenities and purchase of the crutches in view of the medical condition and deformity or disability to an extent of 27% to the whole body, which has been stated on oath by the Dr. PW3. Wherein he has stated that the claimant has undergone disability to the left lower limb at 54% and 27% to the whole body. On these grounds, learned counsel for the appellant claimant seeks enhancement of compensation. Full stop. Para. Per contra, learned counsel representing the respondents controverts the submissions and contentions put forth by the learned counsel for appellant and sustains the order passed by the tribunal. Full stop. He contends that there is no illegality or perversity in the order passed by the tribunal. The tribunal has taken into consideration all the relevant aspects, including the evidence adduced by both all the three witnesses and the documents marked in exhibits, including the disability factor. And having considered all these aspects, is awarded a compensation of 1,50,000, keeping in mind the advanced age of the claimant to be 62 years as on date of occurrence of accident. These grounds, he seeks to dismiss the appeal. Stop. Para. Having heard learned counsel for the appellant, claimant and the respondents. It is not in dispute that on 22/7/2012, when the claimant was traveling on the TVS moped along with the pillion rider, the driver of the car, stated Supra, came in a rash and negligent manner and dashed against the vehicle of the claimant, thereby causing a road traffic accident, due to which a claimant has sustained the injuries. This fact of the matter is elicited by the witnesses by producing exhibits P1 to P7, which are police records, which prove the fact that an FIR and a complaint and a charge sheet came to be registered against the driver of the offending vehicle. Exhibit P8 to P18 are the medical bills produced by both the claimants to show the amount spent by both the claimant herein and the pillion rider in the other connected case. Full stop. Therefore, there is no dispute of occurrence of the road traffic accident in a public place and involvement of these two vehicles in the occurrence of accident and the injuries suffered by the claimant, which are narrated by the doctor exhibit by PW3, who has stated on oath that the claimant has suffered disability to an extent of 54% to the left lower limb and 27% to the whole body. Stop. Though the claimant has stated that he was earning 9,000 rupees per month, nothing has been placed on record to prove the same. Therefore, in the material evidence with regard to proof of income, this court is left with no other alternative but to relegate itself to the Legal Services Authority's standard chart for calculation of income, which prescribes rupees 7,000 rupees per month for the accident year 2012. Hence, it would be appropriate to take the income of the claimant to be at rupees 7,000 per month, as there is no proof placed by the claimant. Hence, income is taken as 7,000 per month. The claimant being aged about from 62 to 65 years, the appropriate multiplier would be 7, as contemplated in the case of Sarla Verma versus Delhi Transport Corporation, reported in so and so. Hence, the multiplier is taken as 7. The Dr. PW3 has stepped into the witness box and stated about the disability and the injuries suffered by the claimant, wherein he has stated that claimant has suffered disability of left lower limb of 54% and 27% of the whole body. This aspect of the matter has been accepted by the tribunal, and the same is not questioned by the respondents. Hence, that has to be taken for computation. Full stop. Therefore, the loss of earning capacity due to disability suffered from the accident caused by the driver of the offending vehicle would be 7,000 into 12 into 7 into 27 by 100. $1,58,760. 1,58,760. as against 1,02,060 awarded by the tribunal. In the 4,000. Seven. 90,000. As against 1,02,060 awarded by the tribunal. Full stop. The tribunal is awarded towards injury, pain and suffering an amount of rupees 40,000. According to PW3, admittedly, undisputedly, the claimant has suffered condyle fracture of left side and crush injury on the left foot. And there's a reduction of the left foot due to the injury. Also, there's a fracture of the tibia. Tibia condyle is one, this one, is it?
Yes, my lord.
Tibia condyle one. Therefore, apart from that, there are multiple injuries and sustained by the claimant.
Fractures on foot, my lord.
The disability assessed by the Dr. PW3 is 54% to the left lower limb and 27% to the whole body. Therefore, the pain and suffering awarded by the tribunal appears to be on the lower side, saying requires a slight enhancement. Hence, 30,000 is awarded in addition to the amount of 40,000 awarded by the tribunal under the head of pain and suffering. Full stop. Next. The tribunal has not awarded any amount towards loss of amenities. I deem it appropriate to award rupees 25,000 under this head, considering the injuries sustained by the claimant. Full stop. It is also seen that the tribunal has awarded an amount of rupees 8,000 towards loss of earning during medical treatment. Full stop. Considering the fact that this court has enhanced the income from 4,000 to 7,000, and the claimant having been admitted in the hospital for more than a month and having undergone multiple fractures and injuries with a disability of 27% and reduction in the left foot, at least 4 months period should be taken as a non-earning period and later period. Accordingly, 7,000 into 4, 28,000 is awarded under the head loss of earning during later period. Dr. PW3 has deposed in the evidence stating that the screws and the removal of implants would require certain expenditure, and so also for future medical treatment, the claimant would require 50,000 for treatment, future medical treatment in a private hospital. I feel this to be on the higher side, but deem it appropriate to award 35,000 towards future medical treatment and for removal of implants. Full stop. The photographs produced by the claimant at exhibits P11 goes to show that the claimant would require assistance of a crutches to walk around in view of the disability of 27% to the whole body. Therefore, 20,000 is awarded for purchase of the crutches for his future purpose.
And food conveyance and attendance has not awarded, my lord. Miscellaneous.
It's also seen that during the period of treatment in the hospital for a period of 1 month, the tribunal has not awarded any amount towards food, nourishment, and conveyance charge. 15,000 is awarded under this head, keeping in view for rupees 500 per month per day. Straight in the total. Full stop. In view of the above discussions, the claimant would be entitled to a total compensation of rupees 760 as mentioned in the table below, as against rupees 1,50,060 awarded by the tribunal. In view of the above discussions and reasonings, I pass the following order. The appeal of the claimant is partly allowed. Claimant is entitled to total compensation of 3 lakhs and odd as against rupees 1,50,060. The judgment and award passed by the tribunal in MVC 7359 of 2012 is modified accordingly. The respondents number 1 and 2 are jointly and severally liable to pay the compensation. The second respondent insurance company shall deposit the compensation, balance compensation amount. ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ. Shall pay the entire compensation amount if already not deposited, the balance amount if already deposited within a period of 4 weeks. Within a period of 4 weeks from the date of receipt of copy of the order. All other terms and conditions stipulated by the tribunal shall stand intact. Any amount here deposited here before this court? Needless to mention that if any amount is deposited by the respondents before the tribunal or this court, a claimant shall be entitled for reimbursement of the amount upon proper verification. The deposit and other things ordered in Illala. The entire amount shall be dispersed in favor of the claimant. Yes. Yeah. P20. P23, P24 record of rights. Yes. Open model. Very delicate one. Yeah, 190 bar 194, 190, 1, 2, 3, 4 is all there. Yeah. Date ilva?
Therefore, should not be treated as Or three. Four. Four. Kind of the mistake that is there.
Uh,
24. What we amending what is the might have been there. But many numbers, so much something called three, is where name of human has been mentioned there. That doesn't matter. But who is the person? It's your opinion.
mm. 4 acres, 14 gupta.
The land scored for 53, which also basis for 24 and 24.
Mm.
But that is very used by them. Cannot use. Thinking of this property not being ascertained. That is. Almost, especially the.
Exhibit B7. B7 is a sale deed. The Timanna. What's the survey number? So that means in 190, there is some portion of land of Chikanna also. In 47.
all calculation follow that.
Hmm.
4 pages there are. It's okay. Like this. Yeah, calculation.
Tabulation.
Calculation.
Hmm.
Party.
Hmm.
Party comments. The next page, serial number.
Hmm. The serial number 6. Hmm.
Password.
Hmm. Yes. 3 acres, 7 guntas.
Famous. That is towards the south. Towards the north, Dari.
Hmm.
Of course, you know the. One part four. How many want to Solam? This was the case. Towards the south, only ಮತ್ತು ಚಿಕ್ಕಣ್ಣನ ಹೊಲ. And towards the north, the person listed. See, here also, the southern portion, attention is the same. What the southern portion comes to there.
Hmm.
Father, chickannana is.
Yes. Hmm. Hmm.
Survey number 189 and government time survey number 2. By Tirumalana of Nagari. South land of Uttarakhand native land. Marked by road.
Hmm.
So reference I just reading here the writing is saying. ಪೂರ್ವಕ್ಕೆ ಮಲ್ಲಯ್ಯ ಮಲ್ಲಪ್ಪ ಇವರಲ್ಲಿ ನಾರಾಯಣ ಜಮೀನು ಅದಕ್ಕೆ ಚಿಕ್ಕಣ್ಣ ಮಾತು ಸರ್ಕಾರಿ ರಸ್ತೆ description of property as mentioned in 1933.
Hmm.
plaintiff is now seeking to make claim. In fact, the property. Sir. Okay, about because there are meters. Therefore, contract is not. This is right away. And then contract has to be released. What was created around what is the score? What is the cover and the party? Along with that, what is it? For the legal. For the certain. Not.
What the trial court did in the suit? Their version. First appellate court changed.
Property was purchased by Concurrent. Must have been surveyed for 193, 190 bar 2 because the so 190 bar 2 because it has 4 acre 14 meters as per NCP. That is the only basis on the first the finding of that is one of the reasons should be reported. First appellate court on the other issue which was changes the suit of the 1984. What
It's a suit for declaration. Why didn't both of you make any effort with regard to finding out as to what is the total extent of land available? Because admittedly, the total extent of 190 is 11.5 acres. 11.35.
The statement that 7 for 190 at level. Where by the four. Not written. Each one of the points. Like this. Not a case of the plea. Because if it was a case of the price, it would have. And these defendants, these two students, they had purchased, there were transactions, then those statements would have been made in the court suit. I'm just reading the what is the article about. When a detailed business was finding ways to make it money. There are purchase of property, apartments created by in the sector.
Explain.
This is what happened. In the I just read couple of lines from the judgment in OS number 89 bar.
Of the trial court. Trial court judgment.
Yes.
That's 89.
89 point. Okay. 15.
Exhibit P15 again.
So reading all the evidence, reading what it's like it's
Judgment Kodima. Exhibit P15. Filed against defendants 1 to 4. That is in Kannada.
because one of the pending further to add 9 where the witness statements are also noted. I don't know the one repetition of BW1. I think the BW by the next. BW2 is not the part. Because BW2.
All right.
I have also made a statement that I am in possession of the property. Because yesterday what seeking the direction. Cause of action, right? It's cause of action, right? It cannot postpone the same. What can the say that I will not treat that as a cause?
When is this judgment in the of this case?
This is the 31st January 1989.
7 or 8?
More than January 7.
89 is the judgment passed. So according to 87 is what it shows.
Because of 1980s. No, 1980s.
So that 87, according to you in the written statement, they have denied the title. Defendants have denied the title. Yes. Yes. Yes.
The other
Nineteen 1947 partition B. Nowhere earlier any records. Existed.
Or stay in the name of. More than 30% of the law. For this is partition, not restricted to only your. It encompasses a number of properties. And we don't look at how after 50 years from the date of execution, the partition will be able to become rightfully legal. That presumption at least is done to my have to pass. There was no bigger doubt. The system of property is there.
Yes.
The description of property is there.
Yes.
Was
ಯಾರ್ದು ಎಲ್ಲಿದೆ No, whether in the partition deed of 1947. Huh?
brother Mariappa, other brother, father.
Kanna, Mallayya, Ariyappa and Channabasappa. So their partition.
There's also like, over the date is concerned.
What is that partition date? Date. 27. All right. Exhibit.
8.
So this partition by Chikanna also was there. Mallayya, Ariyappa,
Channabasappa, that is the
plaintiff. He relinquishes.
Kept outside the share of and his town.
Where does that come from?
But
In this 1975 partition, Chikanna gets 1 acre, 2 guntas.
so far as 194.
That is coming, is shown in the document. Read it. But this aspect is not, this is not considered by the. No, whether this was considered by the trial court. What did it say?
But it says that one figure was only has come to share of the detail. Therefore, it's saying as regards the entire property of the development class. That's the principle.
Okay, read it.
But it's the fourth sheet in the same document. Serial number 12. Of A schedule property. It mentioned survey number 190. Bar 4. Subdivision 4. Section 2. That Begins school by saying, who should know should be ancestor joint family property of native father, native father, native father, and native wedding daughter, and to budget for all separated in the third partition B of the 1965. Yeah, native is something in the therefore, the decision also dependent on the system. That's the great way to or in the description of the problems. Relation. Apart from the area of it. Apart from so that so problem so you feel that's a problem is what that is again numbers are you not numbers they also not the what which is the fact that apart from the revenue increase there were other documents basically 79 being appeared. Don't take lands for 25 for acquisition. The reason for the very same person. Which document? For apart from the review, if one of the documents the then taken that this is the corroboration. Revenue documents. The word is a place of revenue documents also. Exception to the rule or the needs. The documents of stated what the refugees. The financially. For the whole. Those documents are not. Even though the statement is made that you don't have to agree. It's stating that the judgment. Second time, second proceedings. Other constitutions are also considered. But also. Exponents of cases. The first subject.
Yes.
Four. Property of these are also property belongs to the family.
What does he say? There is no. Hmm.
Next, and does not make him a bona fide purchaser for value.
Yes.
Like this one.
ಖಾತೆ ಆಗಿಲ್ಲ ಮನೆ ಎಂಬ ಮನೆಗೆ ಖಾತೆ ಆಗಿದೆ. But further learned counsel Sri Syed Akbar for our appellant for defendant number 2 ಅಲ್ಲ ನೀವು defendant number 2 learned counsel Ajay for defendant number 7 learned counsel MS Rajendra for plaintiff and Shantakumar ಅಲ್ಲ Shantakumar for you are for whom? He also appears for plaintiff. Plaintiff is the connected appeal. The parties have, learned counsels have completed their submission, arguments, filed a list of authorities by exchanging copies to each of them. We will have this matter sometime in the first week of October. Release this matter on 5th of October. Serve a copy and give it. If you also want to file not more than 2-3 pages. Sir. Yes. Correct.
Okay.
This is no representation in this matter is called out at 4:50 PM. Released next week. Same one. Without
Yeah.
you ready now? Release this matter next week. No representation for appellant. Saying no representation.
My lord, I appear for, my lord, 50, my lord, 1, my lord.
39.
Oh, sorry, I am extreme, sir.
No representation on either side. Released next week. Could it. First. 41.
Fine. Sona, what?
ಇದು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ ಇನ್ನು. No representation. Released next week. ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
My lord, 51, my lord.
Tomorrow I don't know. It will not come tomorrow. Day after. 44 listed on 14th. 43 released next week. Wednesday. Number 53. Sir, 2013. Still in 2006 and 7. Same. Yes, name the other Mr.
My lord, 51, my lord.
What do you want?
My lord, not next week, my lord, I will not be in station.
Released week after next. Week after next.
Published.
My lord, serial number 52.
Week after next.
Published, my lord.
My lord, serial number 52. Appearing for respondent number 3.
Released on 29th.
4 minutes I am for the appellant of the year 2013.
Answer the first week, October.
Any
4th
date?
October. 4th October.
Obliged.
Come next week, it will come.
My lord, serial number 52. Maybe a date may be fixed, my lord.
Forty-four minutes ಕಳಿಸ್ತೀನಿ ಮಧ್ಯದಲ್ಲಿ ಒಂದ್ ಎರಡು ಅರ್ಜೆಂಟ್ ಆಯ್ತಾ 49 21 or 26 9. I mean 26. Ah, 26 9. ಅಷ್ಟೇ ಮಕ್ಕಳ ಸಾಹೇಬ್ರು ಹೇಳಿರೋದೆಲ್ಲ ಅವರಿಗೆ ಶ್ರೀನಾಥ್ ಅವ್ರದ್ದು ಮಾತಾಡ್ತೀನಿ ಈಗ ಬರೆಯೋದು ನಾನು $29 ಅಲ್ವಾ ಇದು 55 ಹೇಳಿದ್ರು ಒಂದ್ಸರಿ 42 ಇದೆ 43 ಇಂದ 29 44 49 29 45 ನಾನು ಕೊಡ್ತೀನಿ 46 47 48 also 49 4 10 50 not reached 51 26 9 62 27 9 ನಾನೇ ಕೊಡ್ತಿರ್ತೀನಿ 60 54 not reached 55 29 ಇಲ್ಲ ಶಿಕ್ಷಾ ಒಂದು ಡೌಟ್ಫುಲ್ ಆಗಿ ಹೋದ್ರು ಅವ್ರ ಹತ್ರನೇ ಇರ್ತೀನಿ. ಮಾಡಿ